everyone, I am Dr. Bindu Malviya. I welcome you all to this lecture on trademark. I am from TIMIT, Department of Management, Tirthankar Mahavir University. So let us start with the topic trademark. So in today's lecture, we are going to discuss about basic introduction of trademark, what is a trademark, the definition which is given in the Act of Trademark Law. Then we will see various types of, we will discuss some examples of trademark. After that, we will see what are the trademarks which can be registered under the Act. We will discuss various types of trademarks, classification of trademark. So let us start with the basic introduction of a trademark. So friends, as you can see here, that a trademark for a layman, for an ordinary person, a trademark is a brand name. So let us take the name of any brand. Bata, if we talk of a mobile company, it may be Samsung, it may be Apple. If we take example of television, it can be Samsung, it can be Videocon, it can be Sony. If we take an example of music system, it can be the Sony brand, it can be. So a layman understands a trademark as a brand, the name of the company. So what represents the trademark? So it can be any symbol, any signature, any name, any device. It may be in the form of a label, numerals, combination of colors. So which is used by the undertaking on the goods and services and on the other articles of commerce to distinguish it from the similar goods or services originated from a different undertaking. So we can say that a trademark is the name of an enterprise which individualizes the enterprise in consumer's mind, and it is legally not linked with any quality, but it is in the consumer mind. It is the consumer who connects it, who relates it with some quality. So for a particular enterprise, for a particular organization, it is just an identification mark and nothing related to, nothing to have anything to do with the quality. So now we will see the definition which is given under section 2ZB of the Trademark Act 1999. So as per the Trademark Act 1999, the definition of trademark is: trademark means a mark capable of being represented graphically and which is capable of distinguishing the goods and services of one person from those of the others, and may include any shape of the goods, their packaging and combination of the colors. So there are so many things which are given in this particular definition. It talks about that it can be any graphical representation. So as it can be in the form of any picture, it can be in the form of any mark, any letter, any word, any name. It can be even a phrase, or it includes slogans, jingles. So anything by which a consumer is able to distinguish a particular goods and services from that of the alternative goods and services. So it is nowadays it also includes the shape of the goods and services, the packaging and the color combination of the wrapper or the packaging. So a mark may include any device, brand, any heading, label, name, signature, word, letters, numeral, shape of the goods, packaging or combination of the goods, combination of colors, or many such combinations. So like if we take example of like a name, so there are so many brand names like Bajaj, Philips, then there is Usha. These are the names by which the particular product is known. So it can be any signature also, it may be any word, like for example Honda uses the letter H, Tata use letter T to represent the automobile manufactured by Tata. In this way, it can be any word also. It may be it can be any letter also. It may be any word also. Word includes a combination of some letters. So like Yahoo, Google, Uber. Okay. So boat. So these are the words. So this represents the name of the company. So it can be any numeral also. It consists of like 555. Okay. So it can be in the form of numbers also. It may be the shape of the goods also. Like for example, the shape of the bottle of Coca-Cola, the shape of any perfume bottle. So even this is also the identification mark of a particular product of a company. It can be combination of colors, by just looking at the color of the particular wrapper, the consumer is able to distinguish the goods of the particular company. Like for example, we can take example of Dairy Milk chocolate. So that color, the color of the wrapper, the violet color of the wrapper, that can be used to identify the particular product of a particular company. So the trademark, so what is the job of the trademark? It prevents unauthorized use of an individual's goods or individuals or any company's products or services without their permission. So this is the main idea behind the trademark. So let us move ahead. Now there are certain legal requirements for registration of a trademark. So let us see. The selected trademark should be capable of being represented graphically. It must be able to be printed, or it must be capable of being presented on a piece of paper. Second thing is, it should be capable of distinguishing the goods or services of one undertaking from those of the others. The second most important thing, it must be capable of distinguishing. It means it must not be similar to any other name or any other brand of the existing product. It must be totally different. Even it should not resemble, there should not be any slight resemblance also with that of the other goods and services. Another important thing is, it should be used or proposed to be used marked in relation to the goods and services for the purpose of indicating, or so as to indicate a connection in the course of trade between the goods and services, and some persons have the right to use the mark with or without identity of that person. So it is always in relation to the trade and commerce. With relation to and name of the individual, goods and services can be represented, and it can also be used with the permission of the owner to use such kind of mark. So friends, here you can see some examples of trademark, like Yahoo, very popular. Okay, so Google, you all must be using these products. Coca-Cola, okay, so summer weather, most of the people prefer to have Coca-Cola. Honda, most of the people's favorite automobile company. BBC News, this is media. Then certain symbols you can see. Toyota, name of the company. Pepsi, Mobil. FedEx, name of logistic company. Burger King, that is the burger. Walmart. So here you can see combination of products belonging to different sectors, belonging to different companies. So all these are examples of trademark. So by looking at these marks, you can easily connect, you can easily associate the goods and services of that particular company. So friends, what is the basic objective, or rather you can say what are the functions of a trademark? So up till now whatever we have discussed, only one thing is clear, that a trademark is a mark which identifies the goods and services of a person from the goods and services of the competitor's products. Another thing is, it is used as an identification mark which should not be similar to any other existing goods and services. But apart from this, it has many more functions which we must understand. So first important thing is it identifies the goods and services and its origin. Origin means it tells you who is the manufacturer, who is the service provider in case of services. So that's why it identifies the goods and services. Second thing is, it serves as an intellectual property of the owner. Yes, it is the intellectual property of the owner, because this is the important aspect. It takes creativity, it involves some creativity, it is a time-taking process to design one's trademark, because nobody knows you. People are going to know you by the name of your trademark. So it is a very creative word. That's why it is the intellectual property right of the owner. It builds goodwill and reputation. So if the quality of goods and services of a particular company is liked by the people, if it is preferred by the people, if it is above the if it is according to the customer expectations, then it builds goodwill and reputation among the customers. It is an asset for any company, because if it has a good brand name, if it is capable of building a good reputation in the market, then it can bring more and more profits for the particular company. Like for example, if we talk of Apple, so we all know that Apple is a very premium brand, and the middle class person cannot afford to buy a Apple mobile. So why? Because it has built a reputation, because it is something different, it is unique. So because of that factor, it is able to earn better as compared to the other mobile companies. Then it is used as a marketing tool. It is used for the purpose of advertisement by the marketers, by the companies. It advertises the goods and services, because if we see any advertisement either in the television or in the magazine or in the newspaper or in any other form, so what exactly they want, these people just want that you must remember the name of the company, to remember the brand of that particular company, so that if while you are going to buy a particular product in the market, so you will be easily able to connect the brand with that particular purchase decision. Another important thing is, it creates an image of the goods and services. Yes, if the quality of goods and services is good, then it will definitely create the image, and this image is going to help in the survival of the business. That particular image is going to get more and more customers. Another, last but not the least, that is, it indicates the quality of the goods and services. So it is not the company for which it has something to do with the quality, but definitely if the quality of the goods, if the goods are as per the expectation of the consumers, if it exceeds the expectation of the consumers, then of course the consumers will consider it as a quality product, as a good, as a preferable product for them. So it indicates the quality. But friends, nowadays there are certain certification marks also which talks about the quality of the goods. So they are also part of the trademark. We will discuss in the latter part. So broadly, if we talk of classification of trademarks, so broadly it can be classified into two categories, conventional and unconventional trademark. So what is a conventional trademark? So conventional trademark, basically they rely on the textual representation, visual representation for the identification, and these are mostly very common among the people, and these are used worldwide. then they are subject to some legal requirements and registration procedures as other types of trademark. Conventional trademarks includes any word mark, any symbol, any name, logo, service mark. So that is called as the conventional trademark. Now this is something which is non-traditional, that is unconventional trademark. So unconventional trademarks are different from the traditional forms, and it includes non-traditional elements that may be less common, and they are capable of serving as a distinctive identification of goods and services. So unconventional trademarks are basically some non-conventional elements like such as it can be any taste, or it can be any texture, or in the form of multimedia representation, even the sound, the color, and the scent. It also even includes the scent. So all these are part of the unconventional trademark, which are not so common, but they are nowadays taking place in the market. So here we will discuss some examples of unconventional trademark. So it includes sound marks, like even certain distinctive sound, like in case of mobile phone, there are different hello tunes, ringtones in different mobiles. So like for example Samsung ringtone, the Paytm, we are all using so many UPI Paytm platforms for online payments. So the Paytm has a different music, different sound, by which we can easily identify that the payment is gone to a particular company. So the jingle of Intel, MGM Lion Roar. So these are sound marks, because these are nowadays people are able to identify the product with these sounds as well. Then next is scent marks. So the smell of a particular product, like in case of perfumes, in case of body care products like hair oil, talcum powder, cream, body cream, shampoo, so all these products carry some smell, some scent with them. So even this scent of these particular goods are used as an identification mark of that particular company. Next is the color mark. So color mark, the specific color of the goods, of the packaging, the wrapper of the goods, the packaging color. So all these are color mark. Like for example, I have already discussed this, like Dairy Milk chocolate, that violet color, then Tiffany blue, UPS brown. So these, just looking at the color, we are able to connect that particular product with that particular brand. So next is the motion marks, like moving images, animations that serve as a trademark, like for example NBC chimes, MGM Lion Road animation. You must have seen certain animation. So these are also being used as an identification mark, and they are trademarks. Position marks, specific placement or positioning of the trademark on a product of a particular packaging, like shape of Coca-Cola bottle, placement of Levi's red tag on jeans. So that particular mark is placed in a particular position, that is also part of trademark. Then hologram marks, so three-dimensional images or holographic representations, which are used as a trademark nowadays very popularly, and these are creating some unique visual effects like holographic product labels. So friends, these are the various types of unconventional trademark. So designation of trademark. So here friends, there are certain kinds of marks, certain kinds of you can say designations by which we can understand whether a particular mark is being registered or not registered, or we can interpret certain other meaning of that particular designation. Like if you find this particular TM is written on a particular near the trademark of a particular goods. So TM is used for unregistered trademark, and it is used to promote or brand goods. So basically, when a particular company has applied for a trademark and for the purpose of registration, and it can use this letter TM until the trademark registration is being granted. You must have also come across this particular SM. So what is SM? SM is used for an unregistered service mark, and it is used to promote or brand the services. So when the along with the particular service mark, along with the name of a particular service, if this particular SM mark is used along with the name trademark, then it means it talks about that this particular service mark has been not yet registered, but this will help you to prevent others from using this particular service mark for their goods, for their services. This letter R is used when in a circle, so this represents that a particular trademark is being registered, and this will prevent others from using or copying this particular mark with their goods and services. Now, there are certain rules and regulations, there are certain principles which has to be taken care for the registration of the trademark. So the fundamental principles which must be kept in mind for the registration and protection of the trademark is as mentioned here. So first is the thing is the distinctiveness. Yes, it is very important, because as what is the main function, main objective of any trademark, it must be capable of being differentiating your goods from the goods of the other person. So distinctiveness, your trademark must be different. It should not be similar in any way. Another important factor is the non-descriptiveness. The particular trademark should not be descriptive. It should not talk about the functions of the goods, about the description of the goods. So, like for example, if a product like say if a sugar company is selling this any sugar, so it cannot use the word sweet sugar, because it is known that it is always sweet in nature. So it should not be descriptive. It should not describe about the particular features or characteristics of the particular products or the services. The second is non-deceptiveness. Non-deceptiveness means the trademark should not be similar to any other brand or any other trademark of existing goods and services. So because if it is similar, or if it is deceptive in nature, if the intention of the trader is to confuse the consumers, then such trademark should not be considered for the purpose of registration. Then non-functionality, even this particular aspect must also be kept in mind. So the functions, it should not talk about the functions of the particular goods. Like you must have seen so many cars on the road, so different names like Audi, Hyundai, Honda. So these names they never talk about the function of the particular product. So this particular functionality may be registered with the help of another intellectual property, that is the patents. So the name should not talk about the function of that particular product. So another important thing is non-conflict with the prior rights. It must be so different, so identical, so unique that it should not give rise to any kind of conflict. it should not be it should not use certain symbols like emblem or the tricolor of the flag, or certain letters or certain symbols like which has some religious importance. It should not hurt the sentiments of the consumers. So these things must be kept in mind. So it must be, another important point is, it must be capable of being used in commerce. So the trademark must be capable of being used in commerce only for the purpose of trade of goods and services. The object should not be anything else apart from the this particular aspect. And if all these characteristics, all these principles, rules are kept in mind, then anyone can go for the next step, that is the registration, and the trademark may get registered. As per the Trademark Act, there are certain marks which are capable of being registered in India. So it includes product mark. What is product mark? The mark which is used on the particular product. So usually this particular mark you can find on the package or on the product itself, or to the on the particular building, or even you can find the mark on the uniform or the dress of the employees belonging to that particular company. So these are the various places where you can find the product trademark. The service trademark, so these marks are used by the service providers like the banks, educational institutes, finance companies, banking companies, telecommunication companies, the news, entertainment. So they all use whatever mark they use for the identification that comes under the service mark or service trademark. Then friends, certification trademark. Now this is also part of trademark, because along with the trademark, along with the brand, the company also use some marks to represent the quality, to convey that the particular product is very pure, the particular product is of good quality, the product is tested. So like you must have seen in case of gold jewelry, the sign of hallmark, then ISI mark, FSSAI mark on the products which we use for eating, the egg mark usually used on the some masalas and other things, the silk mark, the fabric, the textiles which are manufactured with the help of silk, there the silk mark is used, wool mark. So all these are certification mark. They talk about the quality of the goods. Next is the collective trademark. Collective mark is used by the employees and the collective group or members of a particular association of a particular group or any organization, like for example Khadi, and the word CM is used by the chartered accountants. So like other includes word mark, sound mark, three-dimensional trademark, color trademark. So all these are different types of marks which you can find registrable under the Trademark Act. So now we will see a well-known trademark. So section 2(1) ZG of the Act defines well-known trademark. In general, well-known trademark is are the marks which are very popular, which are very well known, not at the local level, not at the national level, but they are very popular at even the global level, at the world level also, which has become so to the substantial segment of the public which uses such goods or receives such services, that the use of such mark in relation to the other goods and services would be likely to be taken as indicating a connection in the course of trade or rendering of services between those of goods and and services and a person using the mark in relation to the first mentioned goods and services. These are very known, and they get some additional benefit also because of their popularity. So like some examples here we can see is like Tata, Coca-Cola, Apple, Nike, McDonald's, Google and Amazon. These are few names. There are many other brands also. There are many other trademarks also. So these brand names are recognized globally and are highly valuable assets for their prospective owners. So because of their reputation, because of their image at the global level, they are having their more, the valuation of their particular brand is much higher than the other brands of similar sector. So Indian trademark law accords extraordinary protection to well-known trademarks and recognition on the basis of their international, national and cross-border reputation. So the Act gives protection to well-known trademark at two levels. As I told you that it gives certain extra advantage to the particular owner of the that particular mark. So first thing is against the registration of any similar mark. So as these marks are so popular that nobody can copy the name, nobody can copy the mark. And second thing is action against the misuse of well-known trademark. So if anybody copies or uses any particular well-known trademark without the authorization, without the permission of the owner, then they can take legal action. So now we will see the international classification of goods and services for the purposes of registration of the trademark. So this international classification of goods and services of the marks was established by an agreement which was concluded in the NICE Diplomatic Conference on June 15, 1957, and which was revised at Stockholm in 1967 and at Geneva in 1977 and was amended in 1979. So here it is being revised 4 times. So what is NICE classification? Another important thing is this NICE classification also applies in a number of countries, even those who are not party to the NICE agreement. So most of the companies, so international level, they apply this NICE classification of goods and services for the purposes of registration. This NICE classification categorizes goods and services for the purposes of trademark and service mark registration into 45 classes. It has provided 45 classes, out of which 34 classes consist of goods and other classes, 11 classes for the registration of the services. And these classes, these goods and services are listed alphabetically for specific goods and services which within a particular class. So NICE agreement is a treaty administered by World Intellectual Property Organization, that is WIPO, and as of now approximately 150 trademark offices worldwide use this classification, including US Patent and Trademark Office. So India is also using this NICE classification for the purpose of registration of goods and services. So now let us understand the doctrine of honest concurrent user. So when it comes to registration, when it comes to understanding the trademark, so one has to remember these principles of trademark. So let us see what is doctrine of honest concurrent user. A trademark identical or similar to an already registered trademark cannot be registered, as we all know. As per section 11 of the Trademark Act 1999, A trademark shall not be registered if it is identical to an earlier trademark. This is also very clear what we have discussed till now. This provision prevents public confusion regarding the ownership of origin of the goods and services claimed, and it prevents a mark that is identical or similar to the previously registered mark from getting registered. So this is the basic rule. The applicant can take up several defenses of the Act. So honest concurrent use as laid down under section 12 of the Act is one of those grounds that the applicant can use to evade getting tangled in a trademark infringement battle. Section 12 of the Trademark Act lays down the doctrine of honest concurrent user. So sometimes if any kind of dispute arises, then a particular person can use this doctrine to save himself. So what grounds are required for the purpose of doctrine of honest concurrent use? So first thing is, registration of such a mark is at the subjective discretion of the registrar. Thus the registrar is in no way obliged to register such mark. If there is confusion is arising in the mind of the registrar, then it is totally at the discretion of the registrar whether to continue with the registration or not to get that particular product registered. Some of the documentary evidence which can prove honest concurrent use under section 12 of the Act are, and also some documents which are some evidence which can be presented. It includes, if it is a mark already in use, then the evidence to prove the period of the usage of the mark. So one has to prove that that particular mark is being used for a long time, for a particular period of time. Second thing, advertisement of the mark and the proofs of the amount spent on the advertisement of the mark. If any company is using a particular mark since long in the advertisements, then it has to present the document before the registrar. Third important thing is, the applicant can also produce books of accounts showing yearly sales figures of goods and services offered under the mark. So all these things need to be proved as per the doctrine of honest concurrent use. Another is the doctrine of deceptive similarity. So while registration of the particular trademark, this is also a particular principle which has to be kept in mind by the user and by the owner of a particular trademark at the time of registration. So we all know that the trademark should be unique, the trademark should be different, it should be capable of differentiating the goods and services of one person or enterprise with that of the another. So what is the doctrine of deceptive similarity? A mark shall be considered to be deceptively similar to another if it closely resembles that another mark in such a manner that it is likely to deceive or cause confusion. This concept has been considered as a ground for trademark infringement under the numerous trademark authorities. So even it should not sound similar, it should not look similar, the visual effect should also be different of a particular mark as compared to the others. So even the color, you cannot use the color of a particular trademark or a particular design, the way the particular letters are written, the font which is used, the shape, the design. So all these things are being barred, or all these things are being prevented for the purpose of registration. Another thing is, according to section 2H of the Act, the trademark must deem to be deceptively similar to another trademark if it is nearly resembles with the another mark, as likely to deceive or cause any confusion in the mind of the others. Now you must have all seen in the market, there are various goods which look very similar to that of, like so many duplicate mineral bottles of this Bisleri are being copied. So for educated people, they can easily identify what is original and what is duplicate. But for a person, for a layman, for an illiterate person, they are not able to identify what is original and what is the duplicate. Like you must have also seen many companies are using Adidas in place of Adidas. They just everything is very same. Just they instead of using Adidas, they replace the word das with B and it becomes Adibas. And if you don't read it properly, then you may get confused. So that is called as deceptively similar. That is not allowed. And the concept of deceptive similarity has widely recognized as one of the ground of trademark infringement under the various trademark regimes, and under the Indian legal system, the deceptive similarity is also considered as the ground for not granting a trademark registration to an applicant by the registrar of the trademark. So it is infringement of the trademark law if somebody is using a similar or deceptively similar trademark. As we will see the criteria for a court of law or tribunal to determine deceptively similar, what are the factors, what are the elements which are considered as deceptively similar. So a very landmark case, that is Cadelia Healthcare Limited versus Cadelia Pharmaceutical Limited. This was a very landmark case, and to understand this particular thing, the Supreme Court has laid down certain rules for deciding the nature of similar or misleading marks, and these can be first thing is the nature of the mark, whether the mark are word, labels or composite marks. The nature of the marks must not be similar in any respect. Second thing, the degree of resemblance between the marks, phonetic or visual, or similarity in an idea. So even the idea should not be same, including the sound, the pronunciation, phonetic and visual. The nature of the goods and services in respect of which they are used as trademarks. The similarity in nature, character and performance of the goods and services of a rival trader, service provider. So this has to be also taken into account by the Supreme Court. The class of purchase, customers who are likely to buy the goods or avail the services on their education and intelligence and degree of care they are likely to exercise in purchasing or using the goods. So the class of purchasers and the customers, they are also taken into account for considering whether the brand is distinctively similar or not. The mode of purchasing in the trading channels, that the goods, services, transfers in the course of business or placing an order for the goods. So while nowadays people don't go for shopping because of the so many online platforms are available. So even if you are purchasing certain goods through online and placing orders, so there also it should not resemble with any other such service provider. So friends, the protection of trademark, the law which are related to the trademark are they have all arise from the law of passing off under the Trademark Act. Earlier there was no trademark law. So it does not mean that the mark of a particular seller or the trader or a particular company was not protected. During that time also, earlier also, it was protected with the help of passing off. So let us understand what is passing off. Passing off arises when there are false claims and harm to existing reputation or goods of the owner. Now this usually arises when the trademark is not registered. So earlier there was no such law and there was no compulsion for a particular company or a trader to get the trademark registered. As this trademark law, trademark act, we have seen it has just it is just enacted in 1999. So how the trademark was protected? It was protected with this particular concept. So it is creating some false representation that is likely to lead someone to believe that the goods or services are those of someone else. So the people started taking advantage if some particular goods services became popular and if it carried good image among the public, then the others competitors, they started using the particular trademark for promoting their goods and services. So this is called as the passing off. In layman terms, passing off occurs when a trader or a business person or another person makes a false representation to their customers or consumers to lead them in believing that the goods or services are delivering are property of another person. According to section 134, 1C of the Trademark Act 1999, it establishes the law of passing off to prevent this particular conduct. So this section is being introduced in the Trademark Act to prevent this passing off. So unregistered trademark rights are subject to this common law tort. The law of passing off prohibits one person from impersonating another goods or the services. So the features of passing off, there are main three features of passing off. First is the reputation. Reputation of that particular brand is being, it carries a good image among the customers. Then there is a representation and deterioration of that particular mark. So accordingly, a complainant must prove these three aspects. So first thing is their product or services have a goodwill. Another important thing is they should prove that the other party is making a false representation. Means the goods or the services are not sold by the authorized person, and also they should demonstrate that they have incurred a loss due to the party's false claims. So these three criteria, these three important aspects are required for using or protecting a particular trademark with the help of passing off. So friends, I would like to stop here. We will meet in the next lecture regarding other aspects of trademark. Thank you very much.